All right, everyone, shall we get started? So welcome to today's revision seminar. My name is Sebastian. I'll be running the lecture today from 7 o'clock, about 1.5 hours. We'll be leaving plenty of time. Meanwhile, I have sent in the Google Drive access to the papers for today. So if you guys do have any questions about the materials, feel free to let me know as well. This session will be recorded for information as well. So before we get started as well, I just want to go through a little bit of what's happening. Okay, yeah. I just want to go through a little bit of the lesson plan today as well. And also one other thing, if you guys could just turn on your cameras, that would be greatly appreciated as well. I do want to keep this session interactive. So before I continue further, could you guys just help to turn on your cameras, please? Yes, anyone? No? I see a few familiar faces, isn't it, from the in-person seminars all the time? No one? All right. Okay, but anyway, meanwhile, if you guys have any questions, feel free to type that in the chat as well. And then usually I like to run them in person. Unfortunately, today I just can't do that because there was no available spots. So we'll get this on Zoom. Anyway, here's the lesson outline. So we'll be running through the 2021 papers from semester 2. I'll provide some general tips as well for a start, and then we'll go through the full paper. Just take note there will be these general feedback available on the document as well after today's session. So you will be able to look for something that's pretty much comprehensive, very similar to what you already have. I believe the faculty has given you 2 papers from 2022 and 2023. So we'll be looking at 2021 today. I'll be leaving a lot of time for Q&A as well at the end of this. Okay. Everyone has access to the paper? I'll have it. Okay. Before we continue further, can I just get a show of hand or maybe just get an emoji? Who has wrote full answers to this paper? Okay, if you have wrote full answers to this paper, could you give me a thumbs up? You can do it on the emoji or something like that. Anyone? Who has done the full paper? No one. Okay, I'm sure you guys are really shy. I don't know what's happening. Last year was pretty much quite a fair bit of people. But anyway, yeah, so if that's the case, I'll be leaving you guys some time to attempt this as well between each question. But if not, I will start off with some tips first. Okay. So for those of you who have been doing this cream paper for, let's say, the 2022 paper or the 2023 paper, or if you figure out some earlier papers, there are some of these common issues that you want to take note of, the general comments from past year exam papers. Okay, so I will be, throughout this session, I'll be sharing some tips on how do you want to score well. I believe if you guys are here, I do want to make sure you guys are getting that 80%, 90% for criminal law. Okay, so now the first most important issue that a lot of students are making is they are not identifying most of the offenses raised by the questions. Okay, so for example, in your exam, right, we were told, let me just take a look. For example, the faculty has told you there are 4 questions, right? Question 1, 20 marks. Question 2, 16 marks. Question 3, 12 marks. Question 4, 12 marks. Say you have a murder question for 20 marks. Okay, I'm not saying question 1 will be murder question, but I'm just saying, so suppose you have a murder question. And what happened is that, for example, you only discussed murder, you didn't discuss manslaughter, you think it was murder. You automatically lose a bulk of the marks just because you can't identify all the issues raised in the question. Similarly for sexual offense question. For example, the question involves rape, sexual assault, right? Procuring sexual act by fraud, bisexual, or whatever other kind of offenses. And you only discuss 1 or 2 of them, right? That would be a huge issue. I believe for those of you who attended my lessons regularly, right, the 10 of you or so, this is something that I talk about it a lot in class, right? 10-mark question doesn't mean you only discuss 1 offense. 12-mark question means probably you go 2 offenses, sometimes even 3 offenses. Some of you, actually all of you have done your mid-semester exam as well, right? The mid-semester homework, where it was 20 marks, you talk about offenses against the person. And one of the biggest issues among those lower scoring scripts was that you sort of discuss only one issue, right? If it's a 6-mark question or 8-mark question, discuss one issue only. But that's not the way to go. And so moving forward to final exam, I do want you guys to take note of this and write for all offenses raised in the issue. Okay, effective structure for answering a law exam as well. That's one of the most important things. So you want to let the examiner know sort of what are the offenses. 1, 2, 3, list it out. Right. So again, look at the past examiner feedback for suggested structures as well. You don't want to write in like full essay formats without headings or whatever, because it's very difficult for the examiners to see. And you don't want to just, repeat yourself, sort of, if you're talking about voluntary act for one of the issues already, and then there's another issue, and you still want to talk about voluntary act, and then you repeat. That's not necessary. So you want to make sure, right, related questions are grouped together. Use headings and subheadings as well. So again, this links effectively to structuring your essay. So if you're just using like essays, that's not what law exam is about. You do want to have some sort of headings, subheadings. For example, homicide question, heading 1, murder, and you say, okay, element 1, element 2, element 3, death, human being, causation. Okay, and then subheadings. For example, if causation is the issue, right, you might talk about intervention by third party, intervention by act of God, right? Novel, all sorts of novel intervenience. These are some of the most common things you want to take note of. All right, and then fourthly, I do want you guys to have sufficient exploration of the facts as well in a law exam question. So what this means, okay, sufficient exploration of the facts, right? Your problem question by its name suggests there will be some sort of facts, right? Maybe this person murdered another person, there was sexual offense against one person, there was defenses available in certain sort of scenarios. You do want to make use of the facts, because sometimes, especially, back then when I was doing criminal law as well a few years ago, what happened was there were a few of my friends and myself included. We prepared those law exam scripts, throughout the 11 weeks, past 12 weeks, I've seen a few of my students as well. Right, a few of you guys typing down scripts, 20 over pages of scripts, 50 pages of scripts, right? So, and you just throw it out. Well, that's pretty good for content. Okay, I do want you guys to take note of the facts as well, making sure that you incorporate, okay, those relevant statements into the question. We will figure this out later on as well.
Oh my God, my camera was.
Okay, so it's not sufficient to simply outline the law on the mental element of particular offense, for example, and then say that this will be satisfied. Okay, for example, if we talk about murder, right? You say, okay, murder, you either have intention to kill or intention to cause really serious injury, or reckless to kill or reckless to cause really serious injury. And then you say it's satisfied. It's not enough. You have to sort of explain why. Maybe, okay, there was a tension between two of them. Okay, maybe the two of them are buddies for a long time, and then one day the relationship broke down because of the XYZ, blah, blah. And then the other one of the buddies wanted to kill another person. And in the process of doing so, stab the person, right? So sort of give some sort of explanations to link that proposition to particular facts. Reach a conclusion. Now it's very important for you to reach a conclusion, but at the same time, throughout the past 11 weeks, I've seen some of you guys just asking, okay, whether it's murder or manslaughter, you spend a ridiculously amount of time figuring out. It's not that important to sort of reach the right conclusion in most circumstances, but it is important for you to reach a conclusion. Now, having said that, why do I say it's not important to really reach the right conclusion? First of all, there's no right or wrong really in criminal law. If not, if they're so clear cut, okay, it wouldn't be such a difficult position to be working on in the future as well, isn't it? Now, another thing is that I don't want you to focus too much on just thinking of whether this case is clearly manslaughter or murder, because most of the time for a homicide question, you will be discussing murder, manslaughter by, okay, UDA, and then negligent manslaughter by omission and by act, and then you talk about defenses. So you see the steps 1, 2, 3 going very clearly. Now, that's the main analysis that you should be holding on to instead of talking about, okay, is it murder, is it manslaughter? You might risk losing half of the marks for lack of full identification of the offenses raised in the question. And you also want to conclude on the key points and at the end of problem question. By the way, these are all from your faculty. Okay, your faculty has said the same thing over 20 years, over the past 20 years. So it's really important for you to bear this in mind, not just for this upcoming exam, but all the way when you move on to towards public law, contract, property, constitutional law, corporations, whatever, you will be going through all this. It's the same thing, right? You'll all be doing problem questions. The only thing that you've not been doing is probably foundations of law, right? You do the take-home exam 5 days. That's the only thing. For the next 2, 3, 4 years of your core law units, you'll all be doing problem questions. Obviously, when you go on later on competition and consumer law, for example, you have take-home exam again. So this is a really important skill for you to master. For those of you who have read through or who have already done past exam questions, this is important as well. This is pretty much something that the faculty keeps saying all the time. So the exam consists of 1 problem question. In your case, the exam consists of 4 problem questions in the 2024 semester 1 exam. Okay, so this is 4 questions. So 2021 was 1 question divided into 3 parts. The standard of the answers were generally acceptable with lots of variations, right? So what happened was at the less successful, and it was clear that many students rely on poor quality and outdated notes and mechanically copied content from them. So scripts is one of them, right? We at the LSS provide you with scripts, sort of not really scripts, but sort of contents for you to use easily digestible content for you to use. And some people just copy it as scripts, for example. Now, that's not something that the faculty likes them a lot, because you do want to make sure that you see what happened on the last slide. You do want to sufficiently explore the facts in relation to the law. So it is something we at the LSS provide you to study and easily understand. But at the end of the day, you still want to apply them, not mechanically, but to the question, right? So you need to engaging in detailed application of law to the facts and independent analysis. The better answers show evidence of individual thinking and analysis. They identified almost all or most of the relevant legal issues and dealt with them in a clear and organized manner, making use of the facts provided. And finally, we have the best answers. The best answers methodologically applied the law to the given facts, discussed contested issues from the perspectives of the prosecution and the defense. So you make arguments from 2 sides, okay? Causation will usually be one of the most contested issues from the perspective of the prosecution and defense. For example, what the defense might raise, what the prosecutor might raise, right? The defense probably will say, okay, there's a novel actus intervenus, and the prosecution will say, no, there wasn't, the chain of causation wasn't broken. For example, thin skull rule, those who use violence must take the victim as they find, right? Something that we talk about throughout these lessons, throughout these weeks. Contested issues, what this means, right? So contested issues is something, again, most students fail to look out for. I remember, if you've been attending the past 11 weeks, I remember I talked about this example of a friend of mine in the first criminal law exam. What she did was, she went on to talk about voluntary act for 1 page worth of exam. And she spent 50 minutes of voluntary act. Clearly, it was not something that was that relevant, that contentious. Ended up, she managed to do 1.5 out of 3 questions. What that means is before she even get marked, she kept herself at 30 out of 60. Not something you want to do. Okay, so you do want to spend a lot of time on contested issues. Now, make persuasive arguments by making maximum use of all available facts, right? So you probably want to see, okay, if the exam question tells you that maybe the person is very thin, right? You want to link to thin skull rule, for example. Again, there are many other things. Blood transfusion. Right? Again, these are cases that you want to make use of. Now, source cases and legislation correctly. Okay, this is also very important. I remember yesterday, one of you asked me this question on, okay, what kind of legislation should I prepare myself for? Right. So and my response to this was my response to this is you go to the Crimes Act, source out all the relevant information and source out all the relevant information and print them out even, I would suggest. Just give me 1 minute. I'm just going to type this here maybe actually. Okay. So my suggestion for what you might want to do, give me a moment. My suggestion for what you might want to do is that you want to focus your exam. Okay, this is something I've been saying for a lot. You want to focus on what kind of legislation you want to prepare, isn't it? So you want to look out for, say, the Crimes Act, what you might want to print out for. First of all, you might want to look for sexual offenses. That's section 35 all the way to section 45. You want to have that in front of you readily available. When it comes to murder, homicide offenses, again, you want to look at sections 3 to section 9. Mainly, this is a common law offense, so this wouldn't be that helpful in the end. But again, it's quite important for you to know, okay, what are the sentencing framework along this, right? And when you look at defenses, you're looking at section 322. Now, your examiner tells you that your chief examiner tells you that everything is examinable. Okay, your chief examiner tells you everything is examinable, but they focus on these three. But there's also a possibility offenses against the person is still tested. So you might want to look again, section 15 all the way to section 24. I will print this out as well. Okay, so these are all the, so just give me a moment. Yeah, these are all the relevant information that I will be having in front of me. Okay. Now, another thing you see, finally, they were logically and effectively structured. Again, this boils down to structuring. These kind of things, I think I just need to go through one time, right? It will be relevant to all your future exams, these sort of tips. So bear that in mind as well. That's something I will be printing out materials. These are all the legislation, most of the legislation, pretty much all, I would say, that you need. And you obviously need your case notes. Okay, you obviously need your statements of law. Okay, you obviously need some sort of a script or effective structure, or at least if you've done enough past papers, you'll be able to know. Okay, so these are some of the common issues that we've seen in past exam papers. Okay, so now if you find this a bit repetitive, again, because law exams, if you start to find this a bit repetitive, law exams is not that hard for you. Okay, so but I just want to go through sort of this, because if you know this, you keep this technique all the way from year 1 to year 4, 5, 6, 7. I don't know how many years you go. Okay, so first of all, failure to identify or discuss all the relevant issues. Later on, when we do question 1 about Janice and the sexual offenses in her scenario, we will be seeing that there are a variety of issues in that question. Specifically, there are, okay, I'm not going to tell you how many at this stage. Specifically, there are quite a few. So if you only identify rape or sexual assault in that question, you only get part of the marks, which is not something that you want, because you automatically cut yourself all the marks available for the missing offense. Some answers failed to discuss all elements of the relevant offense. Okay, did not sufficiently distinguish between contested and uncontested issues. Discussed superfluous issues, demonstrating limited gaps of elements for liability. Okay, insufficient application, that's one as well. Believe you can read this yourself, so I'm not going to talk about this too much. Poor argumentation. Okay, that's another issue. Again, treating contested versus uncontested issues, raising counter argument could be some of the things. Inadequate, incorrect referencing. Okay, first of all, you do not need AJLC4 in your exam. Okay, similarly, I know your mid-semester you gave that because it was homework. In exam, you're not required. For example, if you just want to quote, say, Fagan, okay, just put Fagan instead of the whole case, right? The police constable against Fagan, and then you quote the year, whatever. Not necessary. Okay. Students are expected to cite cases from reading guide and relevant statutory provisions. Okay, referencing is a pretty interesting issue. Let me go back to this slide. Okay. So when we talk about sexual offenses, okay, most of the references you should be getting is from the Crimes Act, section 35 to 45. But when it comes to referencing for homicide offenses, you're not going to look at section 3 to 9, like 90% of the time. You're going to look at common law. Okay, you're going to explain why under the common law, okay, your provision, your arguments hold. You look at defenses, you're looking mainly at section 322. You're not looking at most of the things elsewhere. For example, your section 322N, I believe, tells you that self-defense is abolished at common law. So if you start telling all the common law rules about self-defense, you're going to get penalized quite badly. Okay, so and then you have offenses against the person. This again is combination of section 15 to section 24 and your common law offenses. But this you don't have to focus on that much because your examiner tells you the top three is the most important ones. Poor organization and writing. This one you need to practice. That's why I give you this practice. Go and do this practice. Okay, make sure, and then go and do the 2022 paper from Moodle, 2023 paper from Moodle as well. Time management is again very important issue. Last year when I ran this workshop, I saw there were about half the class who did this paper. I'm sure you guys are just a bit shy. Yeah, strange. You guys are just a bit shy today, isn't it? So I'm not sure how many of you did this paper, but make sure you do this in 2.5 hours. Right? If you don't do this 2.5 hours, you do only 3 questions out of the 4 questions in the final exam, then you only cap yourself at 48 of 60, which is not something you want to do. So practice it. Okay, 1 mark is about 2.5 minutes in law exam. So some students clearly run out of time towards the end. This is not something you should be you should be making this mistake if you're aiming for HD in the exam. So do practice, lots of practice, especially at year 1. Okay. Now, I believe I've talked quite a fair bit about exam techniques. Any questions so far? You can unmute yourself and ask me, or you can unmute yourself and ask me, or you can type them in the chat box. Anyone? I'll wait for 2 minutes before, maybe a minute before I continue. Techniques in general, nothing? All right. Okay. So in that case, I will be going on to question 1. So this is from 2021 paper. I've sent the link in the description already. I might just give you guys about 10 minutes. Okay, I'll give you guys 10 minutes to walk through this paper. I'll walk through this question 1 first. We'll start discussing at 7:35. If you have any questions, if you've already done it, you're not too sure, you want me to ask me some questions, you can text me. You can text me as a private message. You can text me such everyone will know. Yeah, or you can take a quick break, 5 minutes break, up to you. But we'll start in 7:35. Make sure when you read this question, type down some of the key contentious issues and how you structure this, and we'll discuss the answers to this. All right. All right, just one more minute and we'll get started with discussions. If you got anything unsure, want to check with me, feel free to type that in the chat box as well. All right, let's get started with discussing these questions. Hope you guys have some time looking through this question. Okay, so and reached sort of answer to this question. So usually 14 marks, you should be expecting about 2.5 minutes per marks. You should be looking at somewhere about 40 minutes. Okay, 35 to 40 minutes for this question. Oh, yeah, around that, 35 minutes. So yeah, if you haven't done it, you want to do it in future, you're watching a recording of this, do time yourself as well. If not, we'll get started. So Janice finished a degree, okay, and then so what happens is that in this question, what I would do when I receive the question is usually I will be looking at the question first, so I know what kind of question it is. So this is clearly a sexual offense question. So if I go back, right, so this will be okay, this will be testing me sexual offenses from section 35 to 45. There was a question in the chat box asking me whether or not they should refer to jury directions. Yes, you should refer to jury directions as well. So I'm only saying the crimes that you should be printing out over here. But there's obviously jury direction 46 in particular, 46, 47, okay, that you want to look at. So and then once you're done with that, right, you mark out, okay, all sorts of the question type, right? One sexual offense, one is homicide, for example. One offense is against a person, maybe one just on defenses, or maybe you get two types of sexual offense question, maybe. Yeah, and then but obviously goes on to different offenses. That could be things. Just give a moment. See if this works better. Yeah, and then the next thing you want to do is issue identification. Okay, so there are mainly three issues in this question. Make sure you get that right first. If you don't get this right, you're going to lose the bulk of the mark. Okay. So first issue is you have okay, you have net. Okay, you have net pass the file and brush his hand against Jenny's breast. Okay. So that would be one type of offense. That's the factual hook. Second of all, let's say my hand could go down a lot further than that and no one else would ever know. That's a quote that's making a statement. That would be another sexual offense. Finally, he smiled at her again, put his hands into her pants, digitally penetrating her. Jenny did not say a word. Okay, that's clearly rape. Okay, so I hope you guys caught these factual hooks. If not, for example, a lot of students last year when we do this question, they didn't figure out this statement could itself be an offense. Okay. So once you're done with this, half the battle is already done because okay, you can already know what exactly to write. Okay, if you go in the wrong direction, you start writing offenses against the person, forced imprisonment, whatever nonsense, right? So then you will not be getting the marks, right? If you tell me causing serious injury, whatever nonsense, not getting the marks because question asking for sexual offenses. And then probably if you can do this, I would say you're better than about 50% of the students. Okay, a lot of people miss this one. And then how to get even better than that, right, is that you go into the details. So let's do this one by one. Let's start off with this one. When it comes to a sexual offense question, you need section 35 to 45 of the Crimes Act. So let me just pull this out first. Can everybody see this one? Hope you can, yeah. So if we look at the Crimes Act, by the way, there are answer keys, but I just want to go through everything before I show you guys the answer key. If you start by looking at the Crimes Act, let me go to the start. Okay, it's quite a fair bit. Sexual offenses starts at section 35. You start off with definitions. Some of these definitions are really important. For example, sexual penetration. When do you require sexual penetration? When you look at section 38, when you look at rape, okay, it involves sexual penetration. For example, A introduces any part of A's body into B's vagina. That would be sexual penetration. Right? And digital penetration, okay, would that be incorporated? Right, digital, right? And then any part of the body. Okay, so that probably will fall under 35A, for example. That would be a definition. And then what else might be? Touching, right? Sexual touching. Touching could be any part of the body or anything else, right? Maybe sexual because of the area of the body that is being touched, genital area. Okay, in case of female, breasts. Taking part in sexual act, again, sexual activity, these are all relevant things. When it comes to consent, the actus reus of rape and many other sexual offenses requires consent. So definition is really important because you have to say consent means free and voluntary agreement, and section 36 subsection 2 tells you section 36 tells you a series of things that consent will be vitiated. All right. If you look at these circumstances where the person does not consent, there are a whole series of things. The person did not say or do nothing, do anything. Would be one of them. Reasonable belief in consent as well. That's a mens rea element. Okay, and then we'll go to all the sexual offenses that you need to know. Obviously, you need to start off with rape. Rape is very relevant over here. Rape by compelling sexual penetration. That could be another offense you need to know. Not relevant on this set of questions. Sexual assault is very relevant over here. There's a touching, and the touching is sexual, and there was no consent to touching, and there was no reasonable belief that of consent to the touching. These are the elements, isn't it? So, okay, if you're able to make out sexual assault, for example, touching of the breast, right, that would be a sexual assault because there was no rape, there was no penetration, but there's sexual assault. Right? Other offenses you need to know: sexual assault by compelling sexual touching. A intentionally causes another person to touch A. Okay. Assault with the intention to commit sexual offense. 42. 43 as well. Threat to commit a sexual offense. That's making of a threat, word or conduct. So words may constitute a threat. So later on, when Ned say my hand could go down a lot further, that would be section 43. 44, procuring sexual act by fraud. Right? By threat, sorry. 44 and 45, procuring sexual act by fraud. So these are all the relevant offenses you know for the purposes of your exam. Now let's start off with the first one. When it comes to passing a foul and brushing his hand against her breast, so we'll go to 40. Right, that's what I will do. When I do this step by step. So we come to 40 first. Okay? So we say, A commits an offense if A intentionally touches another person. The touching is sexual. So you need to sort of figure out what the actus reus is. Okay. One of the students, one of you asked me whether you need to have voluntariness as one of the aspects. You don't really necessarily discuss that on sexual offenses because it's pretty clear cut. But first of all, you need to say, okay, the touching is sexual. The touching is sexual. Why is that the case? Because you go to section 35, 35B, okay, it tells you that defendant seeked the touching for sexual pleasure, right? Pass the foul and brush his hand against her breast. So you go to definition and you say, okay, the touching is sexual. That's the actus reus. Another actus reus is you want to look at consent. Again, when you discuss consent, you'll be going to section 436. Okay, so let's go up to 36. Okay. So first of all, you need to quote subsection 1. You say that consent is free and voluntary agreement. Okay, a person does not consent to act just because they resist the act verbally or they do not resist the act verbally or physically. And then you look at circumstances in which a person does not consent. Okay, Jenny did not say or do anything to indicate consent. So you quote that. All right. And then the question from the chat was, do we have to refer to the jury directions? Yes. So the best answers will stop the answer here on consent. The more mediocre answers will stop the answer here on consent. The better answers will go on to the jury directions. Right? A lot of you forget about this. So if you write that down on your script, you will not be able to forget this. So remember writing down jury directions. So if you go to the jury directions, okay, this is the Jury Directions Act 2015. We will be looking at, okay, let's go down. Okay, we'll be looking at consent, isn't it? So if you're looking at consent, we'll be looking at section 46, directions on consent. You could give some of the preliminary statements if you want to do that. Not necessarily. You can go straight to 46 subsection 4. But let's start off with some preliminary if I were you. I will say, okay, the prosecution or defense may request trial judge direct the jury on consent. And then you want to look at the most important one, isn't it? So you look at subsection 4. For the purposes of section 2B, the prosecution or defense counsel may request that the trial judge inform the relevant circumstances of law does not consent to an act and direct the jury that if they are satisfied beyond reasonable doubt that a circumstance referred to in section 36AA of the crimes that existed, the jury must find the person did not consent. So if one of these 36 exists, okay, the person did not consent. Okay, so this relates more towards the jury directions on what the jury will decide. So it's very relevant to answering this question as well for the first part. Okay. Now let's move on. Let me just go back to 30. Let's go back to 40. Okay. So we've got the actus reus. Intentionally touching is sexual. There was no consent. Okay. And then we go to the mens rea. First of all, there must be intention. Okay. Intention to carry out the act. Okay. That was clearly made out. There's not too much of a contentious point over here. A does not reasonably believe that B consents to touching. Okay. Again, you want to go back to 36A on reasonable belief in consent. Okay. So if you look at this, okay, look at this, depends on circumstances, and you analyze what kind of circumstances. Okay. A's belief that B consents is not reasonable if within a reasonable period, A does not say or do anything to find out whether B consents to the act. So did Ned carry out any actions to find out whether Jenny had consent? Not in fact. So there was no reasonable belief. So that's how I'll make an argument. This will not be relevant because cognitive impairment and mental illness is not really relevant. You might want to talk about the burden of proof being the balance of probability. Okay. So okay, so that's pretty much for sexual assault. That will probably give you about 5 marks to this question. 5 out of 14, I would say. All right. I have the question over here. Natasha asked, I had a question. Do we need to quote full sections of the Crimes Act, like the full section 40 A, B, C, D of the sexual assault? Okay. So I believe Natasha's question is, let me just go to 40 again. So Natasha's question was probably, do you have to quote this entire thing? Okay. You could do that if you want. If not, what I would just say is that here are the offenses. Offense element 1, okay. AR, element 1, touching is sexual. Element 2, consent. Okay. And then MR, intention, MR, reasonable belief. I'll just give this. So if you want to quote the full thing, I'm not stopping you as well, but could be one of the ways to be done. So I would say write out the full answers, figure out what works for you, what doesn't work for you, and then will be you will get the way that the writing that works the best for you. Okay. Now let's move on. So the second offense we have over here is Nat saying my hand could go down a lot further than that, and no one else would ever know. Okay, so that is making of a statement. So this would be a threat to commit sexual offense. Okay. I'm just going to let you guys to read through this for 1 minute first, this part over here, and I'm going to break down the elements in a second. All right, so if we look at section 43, try to commit a serious sexual offense. A commits an offense if A makes to another person B a threat to rape or sexually assault B or third party. A intends that B will believe or believes that B will probably believe that A will carry out the threat. So two elements. First of all, there must be a threat. Subsection 2 tells you that words can constitute a threat. So what we'll be doing is over here, we say the threat is my hand could go down a lot further than that and no one else will ever know. And you say that this is the words from section 43 subsection 2. Okay, and that itself under section 43 subsection 1A is enough to be constituted a threat to assault B, which is Nat in this case. Which is Jenny B. Okay, does Nat believe or reasonably believe that probably believe that A will carry out the threat? Right, then that's the MR. So you have to discuss whether or not Nat intended that Jenny would believe. Okay. So what could be some of the arguments? So this again, there's not much case law around this, I would say, that you apply, at least not from your study guide. So what I would say over here, right, you look at the circumstances, right? So Nat and Jenny, okay. Nat passed the foul brush against his hand against her breast, and she moved further away from him. So Nat obviously wanted Jenny to comply with her orders, his orders, okay, or his actions, and make this statement, my hand could go a lot further than that. So sort of threatening and carrying out fear. And by doing so, Nat, okay, Nat will be able to achieve his sexual gratification and at the same time get Jenny to comply. So his intention is obviously wanting Jenny to comply with Nat. So in that case, Nat does intend that B will probably believe, or Nat will probably believe that the threat will be carried out. So making an argument like that, if you have counter arguments, feel free to do that. So it's just in this scenario, I can't think of anything else that much. If you have something, you can type that and ask me as well. If not, just a statement like that to show that you're applying the law to the facts to the law. Finally, Nat smiled at her again and put his hands into her pants, digitally penetrating her. Jenny did not say a word. So this requires us to go back to section 40. Let me go back to section 40. Okay. Section 40, sorry, section 38, sorry, my mistake. A intentionally sexually penetrates another person. So first of all, there must be sexual penetration, right? Digital penetration will suffice as per Section 35 definitions. B does not consent to the penetration. So the main issue again is consent. Right? So Jenny did not say or do a single thing. Again, look at Section 36. Right? Jenny did not say or do, did not say a single word. Okay, so that's doing nothing. So that could be lack of consent on the facts. And then once you do that, obviously go through a few more from Section 36. Let me just see. So the sexual penetration was clearly intentional. And then you want to argue a few facts from Section 36. And then you look at whether or not there was reasonable belief in consent, right? So first of all, Section 36A tells you that reasonable belief in consent depends on circumstances. And then if Ned did not do anything to find out whether there's consent, there must be no reasonable belief. So if you look at this, all these facts, right? Sang to the song in music, parked, the secluded side street, smiled at her and said he could do wonderful things for her career. And Jenny was terrified and froze. Okay. As he leaned over, she whimpered. Okay. So these are all the these are all the facts. And then once you make all this use of these facts, you say, okay, you conclude that there must probably be no reasonable belief in consent. All right. One other thing you want to take note of is you want to look at jury directions. So you want to look at section 46 of the jury directions and 47 of the jury directions for consent and reasonable belief in operations. If you are not so clear from the previous explanations, feel free to type in the chat box again or explain a bit further. But if not, the operations is pretty similar. You just have to go through this motion. Make sure you don't just write C above in a sense, but you want to still have an understanding of how it operates because these two set of facts are different. Let me just look at the questions. So first of all, so Greta asked a question, would you consider the power imbalance considering the boss and employee dynamic? Okay. So let me just go to this. So is it okay if I just post that in to everyone as well? Yeah. Thank you. Oops. I don't know what happened to this. Sorry, I got the wrong one. Let me just look at let me just look at the two questions I've got so far. So let's answer the first question, please. Would you consider the power imbalance between the boss and employee dynamic? Okay, so let's look at this. There's quite a fair bit of jury directions as well. I'll answer that in a moment. Let's look at 36. So I will definitely consider the power. I will definitely say that the power imbalance is a relevant factor. It does affect the circumstances in which a person did not refer to consent. Right. So you could look at a few things that you might want to apply this fact. You could say that the person submits to the act because of fear of force, harm. Right. That could be one of the things. That could be many different things. And you say, okay, example is the following type of harm. Harm to the person's employment. It literally says over here. So if you're able to make use of all these examples, all this statute, you'll be in very good position. So what I would say, go and print out the jury directions. Sorry, go and print out jury directions. Go and print out the crimes. Go and read through it yourself and really figure it out. There are quite a fair bit of things as well over here. Intimidation, coercion, unlawfully detained, right, is in the car. Right, who is in the car? Jenny is in the parked in a secluded side street. And she froze. So perhaps she was being unlawfully detained. You could make an argument. The person submits to the act because there's abuse of relationship, of authority, or trust. So there are quite a fair bit of things. All right. Next question. Also, how do you include jury directions? And do you say something like the judge would direct the jury to? Okay. Also, how do you include jury directions? All right. There's another question from CC. Hi, I don't understand how the jury directions are used and when they are being used. Very good question. All right. So the jury directions when it comes to sexual offense questions. By the way, guys, you guys are asking a really good question in a sense. Because students who don't put in jury directions automatically wouldn't get that, 12, 13, 14 marks for this question, I would say. Because obviously the best answers will put that in. So first of all, just to give you guys some context, who is the person who is deciding whether or not you're guilty or not in this kind of question? Is it the trial judge or the jury? The jury, right? Yes, good. So if it's the jury, but the jury is even you guys, okay, one of you guys out there could be called to the magistrate's court, could be called to the county court, could be called to the Supreme Court to direct them. So the jury obviously don't know too much of a law. So it's the jury that decides whether or not you're guilty. So what happens is that the prosecutor or the defense could could direct the jury on consent. Okay. So once you talk about consent from the law perspective, you need to talk about it from the human perspective, the jury perspective. So that's how it operates, CC. Okay. So also, Naktara, I'll answer your question as well. I know you have two questions. Just bear with me, please. I'll answer this one first. Direction on consent. So what happens that you say the prosecutor or prosecution or defense, right? So it's not the trial judge. Okay, so it's not the trial judge that direct the jury. Sorry, it is the trial judge that direct the jury. Sorry, but the prosecution may request the trial judge direct the jury. Yes. So I will say the trial judge direct the jury on consent. Yes, that's correct. And then I will say, okay, when you talk about consent, after you talk about all the consent from the law perspective, from the Crimes Act, you move on to a subheading, jury directions, heading. And then subsection 1, the trial judge direct the jury on blah, blah, blah. And then one of the directions is direct the jury that if the jury is satisfied beyond reasonable doubt circumstances of section 36 AA of the crimes that existed, okay, the jury must find the person did not consent to the act. So that would be something that's relevant over here. Okay. Same thing for reasonable belief as well. When you look at 47, you also want to direct the relevant jury directions on reasonable belief. So you go and look through this yourself, find out what is relevant. Okay, that might be relevant. Right. Go and look through quite a fair bit of things. Go and look through what's relevant and point it out. Let me look at other question. Naktara asked me to clarify, does intent for penetration comes under mens rea or actus rea? Intent is the mens rea element. Okay. So intent is mens rea. Penetration is actus rea. Okay. So intent will be mens rea. And next question, we have that. Second question, last year in June, there was some modification to the law. Consent has to be affirmative. How do we incorporate that in? Has that been taught to you guys in the faculty? Because I'm not too sure because this answer key was written in, yep, very good, yeah. So because I'm not too sure of this when it comes to the answer key written in 2021, because the law constantly changes itself, there will be time that the law changes. So if the faculty has explicitly mentioned that this year yeah, it was covered in class. So very good. Yeah. So yeah, if that has been talked about that as well. So let me just paste the question. So since the faculty has mentioned that in class as well, it will be something that where the law has to keep changing. Consent has to be affirmative. So you do want to incorporate that in your responses as well when it comes to when it comes to discussion of consent. So Faye says that, yeah, Faye says, I believe you mentioned it under 36A2. Okay. Let me go on. What other questions do we have? Do we refer to, okay, let's go. you were saying before 1 mark per 2.5 minutes. Would you dedicate 10 minutes to collating all legislation or cases you want to cite? No, I wouldn't do that, Greta. What I'll be doing is I'll be doing that as I'll be doing it as pre-exam work. Going to the exam, I'll have everything I need in front of me. So all the legislation, all the cases, sexual offenses, pretty much all legislation, maybe a little bit of cases. I wouldn't dedicate 10 minutes to that because it's a bit intimidating. So yeah, same thing for future as well. Do we refer to the fear of loss of employment? You could do that as well. You could do that. So everything that's reasonable, you could refer to that in section 36. Next question. Would the defense ever raise jury directions? How would this benefit their case? If it doesn't benefit their case, you just say the prosecution probably would raise it. Yeah, that would be the fine. Because I can't think of a situation as well where it benefits. Maybe it does, but yeah, if you wouldn't have to go that deep in that sense. Next question. Faye asked, how many circumstances minimum would you say? There's quite a few. If you have time, I would say go for 3 or 4 at least. Just to give it, examiners like to see when it comes to when it is comprehensive. Because especially for sexual offense questions, I like to do them because it gives me authority. It gives me the it gives me the ability to go very comprehensively, and it's very easy for me to get full marks for this question if I know the fact and I know the law and apply everything. All right. So I believe that's all the questions. I'll be leaving some time for Q&A as well. So yeah, so feel free to stay back a little bit later on. If not, let's go on. So these are the answers. This is the answer key. I'll be making this available, and actually the faculty provided answers available as well on the Facebook group. If you have not yet joined the Facebook group, please do so. You just have to type. Let me just give you guys the link to the Facebook group, because I believe most of you, some of you might not have joined that. Let me find the Facebook group. Maybe it comes to you guys as a surprise. I know some of you, yeah, I know some of you came in at 6 o'clock. I think there was an inconsistency between the LSS website and the actual recording and the actual timing. So yeah, apologies for that. But yeah, the Facebook group also mentioned that as well. 7 o'clock. So next question. How many words would this answer be? So I wouldn't really actively think about how long this answer. I will say go and do three practice papers first, Greta, and after that, a standard answer. You'll figure out the appropriate length for a standard answer that takes about 35 minutes. Whatever you can type in 35 minutes probably will be will be the required number of words for your scenario. All right. Let's move on. Yeah, we've seen so many members requesting to join a few seconds ago. Comes to you guys as a surprise, isn't it? All right. Before we move on to the next question, I just want to show you guys this thing over here. I believe most of you have seen this. The faculty has told you this is the breakdown for the 2024 paper. So you have 4 questions, 1, 2, 3, 4, 20 marks, 16 marks, 12 marks, 12 marks. 16 marks, you might be looking at sexual offense question. No idea, but if it's 40 marks, 16 marks, you might have 3 sexual offense questions. 20 marks might be a homicide question. Just based on what I think. Obviously, I might be totally wrong. It doesn't really matter, whatever, but it can totally be like a sexual offense for 12 marks and homicide for 12 marks. That's what I'm just saying. But do more papers and you'll be able to see what works best for you. But one other thing is that if you look at the faculty, what did they say? If you look at the faculty, they told you that the focus will be on sexual offenses, murder, manslaughter, and defenses. So that means that you might have 1 question on the cell phone defense. That means that you might have a murder question and manslaughter question separately as 12 marks and 12 marks. Or that means that you could potentially have a 12-mark question on offenses against the person. No idea, no idea, right? So But this is the bulk. So question 2 from the 2021 paper focuses on offenses against the person. I will leave that to you guys yourself. I will not be going through question 2 in that case. But any questions, feel free to email me as well. I will send my email as well in a moment while you read through question 3. If not, we have about 20 minutes left. So I wanted to give you guys a break, but seems like let's go through everything to the end. Let's push through to the end. And then call your day. So question 2 was just really quickly, maybe let me give you 1 minute and I'll talk about question 2. Question 2 is about non-fatal offenses against the person, 25 marks. You see, there's a whole chunk of things. 1, 2, 3, 4, 5, 6, 7. So 7 offenses, maybe 3 marks per offense, right? So if you miss an offense, you miss 3 marks. So just saying. Okay, next one. Last question is about death. When it comes to death, it's homicide, murder, manslaughter question. That's why I think question 1 most likely will be a manslaughter, murder, manslaughter, homicide question. It's 20 marks. It's usually good allocation for that kind of question. So yeah, I'll give you guys maybe 5 minutes. In that case, 5 minutes to read through, and then we'll discuss the answer to question 3. All right, let's go through this question. So question 3 asks us to discuss Victoria's criminal liability in relation to Joe's death. This is a very standard homicide question. By the way, if you have anything, meanwhile, feel free to use the chat box as well. But if not, let's look at the facts and see what's relevant over here. Now, next, Dr. Victoria walked up to the office to visit her father. This is a continuation of question 2, but it doesn't really matter that much. She saw her father lying on the floor covered in blood, asked Joe what happened, and then took the sword hanging in position on the wall and told Joe not to move. And Joe took the opportunity to move forward and punch Victoria in the stomach. Victoria warned him to move back or she would use the sword. And she sounded in front of her. Joe tried to move around, but she turned at the last moment and he was stabbed with the sword. He staggered back and fell to the floor. Ambulance came, required a blood transfusion, but he refused the blood transfusion and died. Very similar to facts of Blau. And a forensic assessment later found that he could have been saved if he had received the blood transfusion. Very similar to the mid-semester, isn't it? So a standard homicide question. The decision for you to decide is not whether this is a murder or manslaughter. Okay, if you choose that this is murder, you decide not to write about manslaughter, you get half the marks right away. But rather, you should be doing murder followed by manslaughter if murder is not made out, and followed by self-defense or defenses in general. In this case, self-defense would be the main relevant one over here. So let's go to the, okay. So let's go through the answers right away because I do want to leave some time for questions. Give me a moment. So question 3. Okay, so answers here. So if you look at the Marcus report, answers here needed to identify the relevance of and focus on the common law offenses, murder and manslaughter. The first issue was whether this voluntary conduct caused a human being to die. So first of all, element voluntary. Okay, you need to quote Hugo. Okay, and then you talk about death of human being, Section 41 of the Human Tissues Act. It was important to show understanding of all elements, including why, okay, this conduct was clearly voluntary on the facts. Another inquiry was causation, right? So you look at the test from Hallett, whether or not it was a substantial and operating cause. The factor or the possible novus actus intervenus you have to mention over here is the refusal to accept a blood transfusion. And this requires application of Blau. Okay, so it requires the you do the analogy by case, by fact, and you say Blau, and you say, okay, in that case, okay, V's refusal to accept blood transfusion was not novus actus intervenus. Similarly, this applies here. This aspect was well done by many papers. So that was the actus reus for murder. And then you follow up with the mens rea for murder. You look at whether or not D had the intention to kill, intention to cause really serious injury, reckless to kill, reckless to cause really serious injuries from crab, right? And the facts needs to utilize over here, right? So you talk about why the argument, right, D intend at least some level of harm given the facts. We follow up analysis of the level of harm intended. And it was also possible for the prosecution to argue that D foresaw the probability of death or at least grievous bodily harm, again in crab. The facts need to be explicitly brought in to make the argument for the prosecution, outline how the defense will make use of the facts under the claim. Right? So you want to go both ways, okay, and argue that. So that's what we mean by arguing both ways. So having talked about the actus reus or murder and manslaughter, you don't stop there, okay? You want to go on to the next step, manslaughter. It could go both ways. You could say murder is made out. You could say murder doesn't make out. This doesn't really matter to me that much or matter in the exam that much. But you go on to murder, assuming you go on to manslaughter, assuming murder isn't made out. Then there are different types of murder, isn't it? So you want to look at UDA manslaughter. You want to look at manslaughter by gross negligence. Gross negligence, there are two types, by act and omission. So you say that First of all, murder requires manslaughter by unlawful and dangerous act, requires the commission of a base offense which caused death. The legislation for this is Lamb and Pembo. I think Greta asked the question about whether to spend 10 minutes, right, for required case and legislation. No, because this is the statement of law. This would requires us to just literally just paste it in the exam. So it's not that difficult. Right? It takes like 30 seconds, 20 seconds, 10 seconds. It's important to establish the prima facie unlawful offense. So you talk about battery and you establish all the elements of battery and say, okay, why is it's made out, and then you talk about UDA manslaughter. Okay, so that's pretty much for UDA. Let's go on to gross negligence. There are two types of gross negligence. First of all, by negligent act, hitting with a sword. This is a breach of this duty of care, the duty of care to not harm others, right? Causing this death. Then you talk about the test in idem. The test in idem says that there is a great falling short of the standard of care that merited criminal punishment. So and then you say, okay, why is that the case? Okay, you make arguments from the available facts. Then what you have to do is you want to talk about omission. Remember gross negligence is by act and omission. So first of all, you say that D has created a situation of danger. So because he has created a situation of danger, you quote Miller as the legislation for this, as the case authority for this. You say there's a duty of act and then failing to act, thereby causing the death. And again, you say why is this a great falling short of the standard of care of a person that merited criminal punishment. So this is the murder and manslaughter discussion. So up to here, you can get approximately like 15 marks out of the available 21, around there. Okay. And then what you do after that, you go on to talk about self-defense. Right? You say that self-defense was obviously relevant. Again, you quote section 322K. So first of all, you say that, okay, there must be the burden of proof. It was on D to raise defense, okay? And then P to disprove self-defense, per 322I. So the elements are here, right? So if she had been a genuine belief that what she was doing was necessary for self-defense, and then also because it was murder, 322K note 3 section 3, suggests that D needs to have a belief that it was necessary to do what she did or to defend against death or really serious injury to self or others. Okay, and then you make an argument again why that's the case. And then you look at the objective element, okay, from 322 subsection 2B. Okay, was it a reasonable response in all circumstances? Again, you have to make arguments. Either way works as long as you make reasonable arguments. Bear in mind, when you talk about self-defense, you're only looking at section 322. You don't look at common law. So some students were confused about the test for self-defense, talk about specific test. Okay, so that will not be good over here. So as long as you talk about the subjective and the objective element, and you recognize that you need to defend against death or really serious injury for self-defense, for murder cases, you will be on good hands. Okay, so that's the main overview for question 3. If you've got any questions in general, okay, now it's time to ask. Okay, I'll wait for the chat for a minute or so. If not, just stay here a little bit. I'll give some concluding remarks on how you could study. Okay, and then I'll call it a day. Should I send the general feedback here as well? I'll post it on the Facebook group as promised, but I'll send the general feedback here as well. Yep. All right, so far I've got 4 questions. Okay, let's look at the first question we have so far. Do we have to go through every manslaughter offense when we do questions like this, or is it enough to just go through once we think it apply? Generally speaking, Grace, I would say everything, especially if it's a 20-mark question, because the ones which you think might apply might not be the ones that some other people might think might apply. What you're doing in criminal law is you're looking at all possible offenses, even if it doesn't apply in the sense. So when you look at manslaughter, generally I suggest you to do UDA, and then gross negligence by act, gross negligence by omission. That's the general structure. Faye asked, could you bring up conditional threats? Let me look at this one again. So there was no conditional threats on this question, isn't it? I believe conditional threats will be relevant for assault. It depends really on the factual scenario because you might want to it might affect intention, it might affect a few other analyses. So you want to look at if you have a specific example, for example, you saw that in past exam questions, look at how the examiner report treats that case, and then I think it will be a good way to go from there. Next question. Oh, wait, Faye says probably not right because it's self-defense. Doing self-defense. Yeah, okay. All right. Next question, Greta asked, I am confused as to how to make a document with authorities. I have my course notes and exam notes, but believe a short document including like voluntary Google substantial operating costs. Dash, do you think this would be worth our waste of time? What I will do, Greta, is that in my exam notes, so you have your course notes, and when it comes to exam script, that might be a separate thing. Some people might incorporate it together. What I like to do is I have my course notes in the style of an exam paper. So so for example, I would say voluntariness, and I'll put Google. And then when it comes to causation, I'll say that there must be a substantial operating cost per header, and I'll list sort of the novus actus interveners as the examples. So if you want to look for specific examples on how I would do this, just the LSS sketch notes written by me, by the way, it will be a very good example. It might not be all correct stuff because obviously law do change sometimes, like what you say 2020, 2023, they added some things. So but nonetheless, it might give you some inspirations as to how to go about that, and then find out your own style that works best for you. Next question. Are non-fatal offenses consequence offense? Oof. Can't really remember this, honestly speaking. But I know what you're talking about. So I can't really remember this one off my hand, whether or not non-fatal offenses are consequence offense. But what I would say, what might be relevant in this case, if you look at non-fatal offenses against the person, just limit your discussion to that. Sexual offense, just limit your discussion to that. Murder, just limit the discussion to that. Whether or not they are consequence offense, I wouldn't really think that's too big of a difference into your analysis. At least maybe when it comes to intention, yeah. Because I did see this term before, but I can't remember it offhand. Next question. Suani, was it? Sorry. All right, let's see the next question. If murder is already made out, do we still have to go through manslaughter? Very good question. Yes, you have to discuss manslaughter still, because it's 21-mark question, remember? Right? So if you don't discuss manslaughter, you're not going to get the mark for exam purposes. But even in real life, for example, if you're the prosecution, you made out murder, and then if you're the defense, for example, you're charged with murder, you're going to try to prove your manslaughter, isn't it? So And the prosecutor will still have to discuss manslaughter because they want to show why it's not manslaughter. So you do want to discuss both. All right. Next one, can you outline the offenses in question 2, please? I would love to do that actually, but unfortunately running a bit out of time. So you feel free to send me an email as well for question 2. If not, I would suggest you to look at the general feedback document. It tells us all the offenses relevant for that question. Sabrina asks us, how do you prove or justify intention? Do we have to spend time talking about it if it's not contested? Spend very little time talking about it if it's not that contested. For example, voluntariness would be one issue, intention would be one issue that's generally less contested, especially for say, sexual offense question. In question 1, next question, when it was penetration, digital penetration, there's intention because maybe he wanted to satisfy himself, or even on the facts it's clearly made out. If that's the case, really, you could say. But when it comes to murder question, you want to apply the facts. Let's say, for example, 2 persons, they are big enemies, and then one of you shoot one another. And the facts tells you that they're enemies for a long time and they had the hatred, and he pressed the gun and shot that one person. Then you might want to make use of those set of facts. So it depends on whether or not it's contested or not. If it's not contested, very briefly. If it's contested, go a bit deeper. And then how do you justify? Make use of the facts available to you. All right. I believe that's pretty much all the questions that we have so far. So thank you everyone for joining us today. Moving forward, I believe your law exam is in about 2 weeks' time, slightly less than 2 weeks' time. There are at least 3 papers available to you right now, 2022, 23, 2021. Okay, if you got some old paper from wherever you got them, it's good to do it as well. Do at least 1 or 2 under timed conditions just to get yourself an idea. You do want to mark them yourself as well to see how you're doing. Okay, that really helps you to get the HD benchmark. So that's what I would say. If you really want to do well, do practice papers, mark yourself, okay? And then form study groups if you feel like it, there's a long journey ahead in front of you. But anyway, I thought the past 12 weeks was very pleasant to teach you guys as well. So thank you all for joining us as well in this journey. And I wish you guys all the best. I will see you guys sometime around the law school. Okay, that's all. Bye-bye.
Thank you.
Thank you.